Today, we're talking about your secret legal superweapon. It's not about big courtroom showdowns or dramatic lawyer moments. Nope, it's about the one strategic move that can actually win the fight before it even really starts. All right, so let's say it's happened to you. Someone owes you money. A client won't pay, or maybe a contract's gone completely south. You're frustrated, you're angry. What's your very first move? Your gut instinct might be screaming, right, I'm taking them to court. But here's the thing. That's almost always the wrong move. And here's why. Because the real battle, the one that actually decides the outcome, it happens way before you ever set foot in a courtroom. It all starts with one single, perfectly crafted document. And that brings us to this, the letter before action, or LBA for short. Now, let's be crystal clear. This is not just some angry email you fire off. This is a formal, totally required step under the UK's court rules. You have to do it before you can even think about filing a claim. Its whole purpose is to make sure going to court is the absolute final last resort. Think of this letter as doing two critical jobs at the same time. On one hand, it's giving the other side one last, very clear opportunity to sort things out. But the second part, this is the genius of it. It's your proof. It's you, on the record, showing the court that you were the reasonable one, that you tried to avoid a fight. You're grabbing the strategic high ground from the very beginning. So you might be wondering, how can a simple letter have so much power? Well, it's because this isn't just a friendly suggestion. This thing has real legal teeth. And those teeth, they come from something called the Civil Procedure Rules, the CPR. Basically, this is the official rule book for the courts. And rule number 1 is that courts really dislike it when people rush into litigation. They want you to sort it out yourselves, and the LBA is the main tool they use to make sure you've tried. And what happens if you ignore these rules? Well, it can get ugly. A judge can hit you with some pretty serious penalties. I mean, think about this. You could win your case and still be ordered to pay the other guy's legal fees, or you could lose out on interest you were owed. It's no joke. The risk is absolutely real. Okay, so we know it's powerful, we know it's important, so how do you actually write one that works? Let's break down the anatomy of a perfect opening shot. A really effective LBA has 6 key ingredients. First, the title. You have to call it a letter before action. No wiggle room there. Then, right at the top, you mention the court rules. After that, you lay out the facts, short and sweet, say exactly what you want, list the proof you have, and finally, you hit them with a clear deadline and state the consequences. Now, a lot of people might start a letter like this, right? I am writing about the money you owe me. It's fine, I guess, but it's weak. It's so easy for the other person to just ignore it or toss it in a pile with other bills. It has no urgency. But what if you started with this phrase instead? Whoa. See the difference? That one sentence is a complete game changer. It's like a flare going up. It tells them, and more importantly, it tells their lawyers, I know the rules, I'm not messing around, and this is now an official legal matter. Okay, so that leads to a really important question. Does it actually matter who sends the letter? I mean, can you just write it yourself, or is it better to get a professional involved? Oh yeah, it makes a massive difference. A letter from you, well, they might just think you're bluffing, but a letter that lands on their desk with a law firm's name at the top, that has instant, undeniable credibility. The psychological punch is huge. Suddenly, it's not just a disagreement between two people anymore. It's a real, formal, legal problem that could get very expensive for them. Exactly. It's not just a letter at that point. It's an escalation. It screams, I've already spent money on this, I've gotten professional advice, and I'm ready to go all the way. And for the person on the receiving end, the cost of ignoring you just went way, way up. All right, let's put some numbers to this. I've been saying how powerful this document is, but just how powerful is it, really, when you stack it up against everything else in the process? We've talked strategy, we've talked psychology, but when you look at the hard data for getting a dispute settled before court, what is the single most influential piece of paper? The answer is pretty shocking. I mean, just look at that. It's not even a contest. The letter before action accounts for up to 80% of the influence on whether a dispute gets settled. The actual official court forms, they barely even move the needle. It's incredible. This letter isn't just a move in the game, it is the whole game. And remember, when we talked about having a law firm send it, well, get this. The source material calls that a supercharged effect, boosting the impact to what they call a relative impact of 120%. That extra 20%, That's the power of credibility, of guaranteed compliance, of pure psychological pressure that you just can't give on your own. It completely flips the script. You really can't say it any clearer than this, and this is a direct quote from our source. The LBA is the primary strategic weapon for shaping whether litigation happens at all. It's not just a formality. For most successful outcomes that avoid court, this letter is the entire process. And that's what it all boils down to. The next time you find yourself in a dispute, the question you have to ask yourself isn't, should I write to them? The real question is this: are you just writing another letter, or are you preparing to win?